I'll be sharing the presentation with Benedetta Turchetti. And so, first of all, I will talk about the obligations a researcher must follow under ABS and what happens if they don't. And then Benedetta will share some useful tips on how to handle ABS effectively in research. So, as it was mentioned in the introduction, the first challenge researchers face with ABS under the Nagoya Protocol is that if they want to use a genetic resource from a country that regulates access, they may need to obtain a permit and engage in bilateral negotiations with the provider country to share benefits with that country. So the bilateral ABS system built under the Nagoya Protocol is grounded on the recognition of the state's sovereign rights over natural resources. So, in the past decades, many countries have introduced measures to regulate access to genetic resources within their territories, while others, exercising their sovereignty rights as well, have not. As it was mentioned in the introduction, it is important to consider that the Nagoya Protocol has an extremely broad scope, potentially covering all non-human genetic resources, even if human pathogens are included. And then the set of definitions provided by the Nagoya Protocol is quite generic, somewhere lacking, which has led to a fragmented and inconsistent landscape of national laws. In other terms, ABS laws currently in place in different countries are not harmonized with each other. Instead, they differ greatly in their scope, procedures, compliance rules, and even in the documents required for access and benefit sharing agreements. And later, I believe Manuela da Silva will share some examples on how these legal frameworks may differ. So this lack of consistency creates obstacles, especially for researchers working on projects that involve genetic resources or traditional knowledge from multiple countries. Last but not least, don't forget ABS, it's not just about the Nagoya Protocol, because while the Nagoya Protocol remains a key international treaty with its bilateral system between user and provider, there are other frameworks which regulate ABS for specific genetic resources and purposes, which are in line with the goals of the CBD. For example, I here included the ABS multilateral mechanism under the Pandemic Influenza Preparedness Framework agreed among the WHO, and the International Treaty on Plant Genetic Resources for Food and Agriculture agreed among FAO, which applies to some crops listed in its annex for food and agriculture utilization. And then, moreover, the ABS landscape is also evolving and expanding with new multilateral mechanisms for benefit sharing, which are emerging and that will become operational in the near future. I here mention the mechanism adopted for marine genetic resources, another multilateral mechanism for the sharing of benefits. For these marine genetic resources accessed in high seas under the Biodiversity Beyond the National Jurisdiction Treaty. And then there are some contexts where the bilateral system for ABS was already considered inappropriate in a way in the international discussions. And as a result, other multilateral mechanisms for ABS were created to address these specific issues. I'm referring to pathogens under the new WHO pandemic treaty agreed just a couple of weeks ago after the COVID-19 crisis, and the upcoming CBD mechanism for accessing for sharing the benefits for the utilization of digital sequence information. And we'll hear more about this new and critical CBD decision for ABS for DSI from Amber Scholz at the end of this panel. So, one of the first steps to take in managing this complex landscape is to identify the legal sources of ABS requirements and obligations which are relevant to your research project, because these obligations can exist at multiple levels. First of all, at the provider country level, because there may be specific rules set by the country where the genetic resources you're interested in originate. So for example, if you need to utilize a genetic resource which originates from Kenya, you have to comply with the rules set by that country. Then at a user country level, the country where the research is taking place may have its own compliance requirements to ensure ABS rules are followed by the users. So if your research, for example, is taking place in Germany or in any other country within the EU, you must follow the obligations set out in the EU Regulations 511/2014. 2014, which means seek, keep, and transfer all the relevant information on ABS compliance, which proves that there has been a legal access to the genetic resources you're using. And then you have to submit a due diligence declaration at a certain stages of your research. And then between these two levels, there is a case-specific level, because following the previous example, once you may have obtained an access permit by the ABS National Competent Authority, and for example, successfully negotiated an agreement for sharing the benefits with the Kenyan National Authority, you must carefully adhere to the specific conditions for resource utilization and benefit sharing, which are outlined in those documents. So now let's explore what happens when ABS obligations, which are set in these various layers of sources, are not met. So non-compliance can have serious legal repercussions, both in the provider country where the genetic resource originates and in the user country where the research is taking place. In a provider country, if a researcher violates national laws, they may face penalties and sanctions, which could include fines, financial sanctions, or in some countries, for very severe infringements, also imprisonment. Then the local authorities may revocate your permit or, for example, issue a ban for future access. Then at the next level, for your case-specific obligations, if a benefit sharing agreement is breached, it could lead to financial liabilities or legal action under contract laws. And then in your user country, a violation of ABS laws in the provider country or an ABS arrangement may trigger legal consequences for the researchers too. For example, under the EU ABS regulation number 511/2014, researchers may face administrative or criminal penalties for non-compliance, prohibition of utilization, or the seizure or confiscation of non-compliant material. And here I would like to highlight that countries collaborate when dealing with alleged violations of ABS laws or regulatory requirements, with sometimes reciprocal notifications. So when we talk about ABS compliance, we often focus on sanctions, penalties, and contractual liabilities, but the consequences go very far beyond that. So failure to comply with ABS regulations can have hidden risk that affect multiple aspects of research and professional standing. Here I've represented this situation using the classic iceberg image, and above the waterline we see the direct legal consequences. So for example, sanctions which are outlined clearly or less clearly in a law. However, beneath the surface, there are a whole series of indirect risks that are not immediately perceptible. So which are those hidden risks? Well, ABS non-compliance can jeopardize funding opportunities for your research, making it harder to secure grants for your ongoing and your future research. It may impact research publications, and I'll give some examples about this in a minute. It may compromise the possibility of depositing the material in a public collection, because if you have the intention to deposit a material in a collection, as we said in the previous panel, the collection may require you some documents which states your ABS compliance, and if you cannot provide these documents, that could lead to a rejection of the deposit. And then this can undermine intellectual property rights, posing some legal challenges on the to patents or innovation based on genetic resources. Moreover, beyond these practical consequences, ABS violations can have long-term effects on career and credibility because non-compliance can damage also professional reputation or career opportunities, as institutions and funding agencies may prioritize ethical research practices. So I'd like to share with you some practical examples of the hidden risks of non-compliance with ABS, starting from the area of publications. So there is a growing trend where compliance with ABS requirements is becoming a key condition for publication in international academic journals. Here there are two examples from the editorial policies and author guidelines that require authors to clearly state their ABS compliance. And these policies emphasize that missing or insufficient information on ABS compliance may lead to a paper rejection. And this is before publishing your manuscript, but which are the consequences of violating ABS regulations or failing to comply with ABS requirements after publishing an article? So ABS non-compliance here could lead to the retraction of the paper. Here there is an example of 2020 from the Journal of Natural History. In this case, researchers published a paper describing new discovered insect species based on DNA sequences where the barcoding was conducted in the field. And I would like to highlight here that researchers had a regular permit to access specimens, but not to publish genetic data without a further authorization. So after this paper was released, the national competent authority from the provider country flagged the issue, notifying the publisher. And as a result, the editor had to formally retract the paper with a formal statement. So the key message here is that when the researchers don't follow ABS rules, that may put their work at risk. Last but not least, violations in ABS obligations can attract public scrutiny, damaging reputation in ways that are really difficult to reverse. This slide includes a couple of screenshots of the media coverage on two cases, one involving the misappropriation of a genetic resource, a spider in this specific case, and another involving the misappropriation and misuse of traditional knowledge from another country. And you can see that how these behaviors can also be labeled as acts of biopiracy. Is this naming and shaming a common practice in ABS? Well, many mega diverse countries with long established and robust frameworks in ABS have been very active over the past decades in detecting and exposing cases of non-compliance, often with the support of NGOs. And that's because cross-border enforcement for them has been a challenge for the past decades, and in some ways is still like this. And so as a result, public naming and shaming has become a powerful tool to discourage violation and stigmatize unethical practices. So it goes without saying that once linked to unethical or illegal practices or biopiracy, a reputation damage is deep, long lasting, and far harder to erase than any other legal penalty. So, in conclusion, I want to leave you with a few key takeaways as you navigate the ABS obligations ahead. In my experience as a legal, I often see that when we focus too much on dissecting rules, clauses, and specific obligations, we risk losing the sight of the bigger picture and somehow, sometimes even the fundamental rationale behind the laws. So here are just some simple principles to bear in mind, and I hope that they may serve you as a compass for navigating your ABS journey. So remember, the sovereignty rights of countries over the natural resources is a principle that grants countries the authorities to control, manage, and exploit their resources within their territories. So free access to genetic resources is not the default rule here. Some countries regulate access while others do not. So always check the specific requirements before proceeding. And that brings me to the next principle, which is multiple origins, multiple rules. If your research involves genetic resources from different countries, you'll need to follow multiple regulations. So each nation has its own ABS rules, and there's no one size fits all here. Last but not least, ABS is a long-term responsibility. So obtaining a permit for genetic resource access is just the beginning, and it comes with lasting obligations. So be fully aware of your specific commitments. So there may be conditions in your permits and in your documents for publication, for data dissemination, such as sequence sharing, that you must respect. So keep your obligations in mind throughout the entire research process and ensure that everyone involved in your project is informed and compliant. So I think that I ran out of the time, and so I apologize for that. However, I thank you for your patience. And at this point, I will hand the floor over to Benedetta, who will share with us some practical tips on how to manage if in effective way ABS in your research project. Thank you very much.